office mate, Amy S. FitzGerald. She's been a lawyer for over 20 years and is currently working with BC Society of Transition Houses as our legal coordinator, developing the legal education and training materials for frontline workers and children who witness abuse counselors. In British Columbia, Amy has also been a policy analyst and has consulted on projects relating to risk assessment in violence against women cases, mediation in family court matters, and safe transportation needs on the Highway of Tears. Previously, Amy served as an Assistant Attorney General in the Criminal Division of the Vermont Attorney General's Office in the United States. At the AG's office, she worked on unsolved homicides and was the domestic violence prosecutor, working on policy, legislative, and training issues relating to domestic and family violence. She was the founding chair of Vermont's Domestic Violence Fatality Review Commission and served on Vermont's Child Fatality Review team. In addition, Amy was a public defender and a legal aid staff attorney in Vermont and an attorney at the Legal Aid Society Criminal Defense Division in New York City. So I'm going to hand this over to Amy, and welcome.
Yeah, thank you. Thank you, Rhiannon, for that introduction. So again, my name's Amy FitzGerald. I've been with BC Society of Transition Houses since July, working on the legal toolkit that we're going to be reviewing today. And I am accompanied here with my colleague, Rashid, who is, some of you may have met here at the office, and he's going to be my technical support. And before we get started, we just wanted to go over a few housekeeping items. And we wanted to let you know also that this is our first time doing a Ready Talk webinar, so there may be some growing pains as the afternoon goes along with you. So we're scheduled to chat with you from 12 to 1:30. And just the housekeeping matters are as follows. Currently, you're all muted, and we're going to be allowing for questions to the presentation to be raised in the chat function, and then Rashid is going to be monitoring the chat function throughout the webinar, and he'll be flagging the questions. And the plan is to leave time at the end to stop the recording and then allow us at that open format discussion time to address the questions that you've raised and that you've flagged. So currently it's being recorded, the webinar, and we will be placing it on the BCSTH YouTube link for future reference and also for your colleagues who weren't able to join us today. The other housekeeping matter is if folks are having technical difficulties in terms of signing in, or if there's something wrong with the PowerPoint presentation or the chat function, basically any technical difficulties, our colleague Paka here at the BCSTH office has offered to field those calls or emails, and she can be reached at paka@bcsth.ca, and her phone number is, if you want to use the toll-free number, it's 1-800-661-1040, and her extension is 231. And she's happy to help you in any way to get you connected. So I think that's all for the housekeeping matters. Rashid is going to join now with one more.
Hi everyone, it's Rashid. Just one thing Amy missed out. People who are on audio, I don't think you can use the chat function at the moment, so if you do have any questions, just note it down and we will come to it towards the end of the webinar, sorry.
Right. So we're going to build about a half an hour in at the end for questions, so we should have enough time. And the other item is that we're going to be using a PowerPoint today, but I did send as a downloadable file a copy of a case scenario that raises some of the issues that the CWWA workers have brought to our attention. And it's a slide in the PowerPoint, but it's very small font. So if you want to download that one-page case scenario, you can also use that as we go along. So we're going to be using that case scenario to walk you through the webinar. So without further ado, we will proceed. All right, so Rhiannon kindly did the introduction for me. I'm just going to give you a brief overview of the BCSTH Legal Toolkit project. It's funded by the Ministry of Justice Civil Forfeiture Office grant. It will be available in terms of you guys getting hard copies of it at the end of March, beginning of April. The final toolkit has been drafted, and it's in our colleague Hannah Lee's capable hands to make it beautiful and ready for action. So it will be hard copies will be distributed to all the member programs. It will also be available on the BCSTH website to be downloaded, and then the library will also have additional copies of it. So it should be coming to you in due time. And let's see. All right. So this project was based on a grant that was written by Catherine Talbot and Andrea Thompson when they were here, when Andrea was here, and it was specifically to try and address some of the legal issues that were being raised by frontline workers, sector-specific legal questions. And so the idea behind this grant was to provide you with user-friendly resources and information sheets, templates, links to legal resources and materials, and to do webinars on those resources to supplement the hard copy. So we consulted with the BCSTH member programs. We did an online survey, and probably some of you filled it out in August and September of 2015. And we were very fortunate to get a very robust response in terms of the survey. So we had BCSTH member programs across BC responding. We had over 80 responses, and all the regions and all the programs were represented. The 46% of the folks who responded were from transition houses, 36% were from the CWWA programs, and then the balance were from second, third, and safe homes. The highest response rate was for frontline workers, which was 62%, with the balance from management. And the results of the survey confirmed a strong interest in the topics that we had identified in the grant application, and also allowed us to supplement that list with more relevant topics for you. So I'm just going to advance the slides. So the outline of the toolkit it's going to be when you get the hard copy at your program, it is going to be in a 3-ring binder. It's designed to provide you with a comprehensive overview of the legal issues you've identified, but it's also designed for the individual information sheets to be pulled out and used as you see fit depending upon your work and your program. And I indicated to you what the rollout of the legal toolkit was, so you should be having it, as I said, at the latest, it would be coming to your program in April. And the way that we would like to use the toolkit going forward is to see it as a sort of a responsive living document, sector-specific, and something that can be revised and added to as we go forward. And to sort of treat it as an opportunity to have dialogue on these issues and to really make it useful to you guys in the field who are addressing these different and difficult issues. So the next slide is the font is very small, and I apologize to that because it's a shot of the table of contents that's in the toolkit that's in the process of being finished by Hannah. But basically, just to give you a sense of the topics that we're going to be covering, it's responsive to questions relating to overview of British Columbia courts, overview of accessible legal resources, accessible legal services, and also it addresses the issue of the appeal of denial of service by legal services, which had been raised by a number of frontline workers. We have a section about how to prepare a client for court, specifically how to assist that person with affidavit writing and being a witness. And we have a section on how to identify the different types of protection orders that are available to your client, and to assist them in terms of making a determination as to which order would be the most protective and most useful for them. We have a fair amount of the toolkit relates to note-taking and client records, as well as records management and records retention and destruction. So that's a topic that is a very weighty topic, and we're going to talk a little bit about that today in the case scenario. We also touch on responding to subpoenas and records requests. And then we attempted to identify some specific populations, such as the issues raised by CWWA folks so far, along with issues related to immigrant and refugee women, women and children with disabilities, and Aboriginal women and children. And as I stated, this is a start, and we can always add new sections, and we can also revise the ones that we have to make them more relevant and more useful for you. Sorry, I apologize. I'm having a hard time advancing. There we go. So this is the case scenario that I sent out to you as a downloadable file, and it's something that hopefully addresses some of the issues that the CWWA workers have raised. And then my idea is that we'll have this case scenario, and then I'll show you how the toolkit can help you when you analyze a scenario like this. The case scenario is as follows. A CWWA worker has been working for 2 years with a mother and child who have both experienced violence by the father. During regular counseling sessions, the CWWA counselor has witnessed significant progress with the child, who is now 11. The CWWA counselor has a supportive relationship with the mother that has included assistance with her legal case, such as writing a letter regarding the child's safety and residency. Unfortunately, recently in court, the father has just been granted unsupervised visits by the family court, as well as joint custody and joint guardianship, which has raised new issues with respect to the case. So the first issue that we're going to be talking about is the question number 1. So it specifically states, the father has written a letter to the CWWA program demanding that they no longer see the child, as he did not give permission for the counseling. In the letter, he threatens to sue the program if they don't stop the counseling. The CWWA counselor advises the supervisor of the letter, and the program is considering discontinuing services. So with respect to that issue, which had been an issue that was raised from the Children and Youth Coordinator here, what we've attempted to do, how we've attempted to respond to that in the toolkit, is that we have a section entitled Parental Consent and CWWA Counseling. And it specifically, the question that is posed in that section is, can only one parent consent for a minor child to participate in services such as the CWWA program? And I'm going to advance to the next slide, and I'll, as we go through this case scenario, I'll read the remaining questions once we get to that section of the PowerPoint. So with respect to this issue, I'm going to walk you through some of the topics that are addressed in the toolkit to give you a sense of how you would use it. So if you were posed with this situation in your practice, you could go to the Parental Consent and CWW Counseling section. And there you would see that the Provincial Family Law Act would provide the framework to analyze who needs to consent to allow a minor child under 19 to access the CWWA services. And this is the act that came into effect in March of 2013. Section 39 of the Family Law Act specifies that if the parents are living together or living separately, each parent is a guardian of that child, and as a guardian, the child has parental responsibilities towards the child to be exercised in the child's best interest. And the Family Law Act, as folks are probably very well aware of, it really makes the best interest of the child the only consideration when decisions affecting the child are made. And that's something that I think can help you in your practice when you're trying to analyze these kinds of situations. And as defined by the Family Law Act, to be in the best interest of a child, the decisions must, to the extent possible, protect the child's physical, psychological, and emotional safety, security, and well-being. So that's, I think, a definition that could probably help you in terms of identifying if you feel that this counseling is appropriate for this child and is in their best interest. There's language that can assist you in making that case. Section 41 of the Family Law Act details the responsibilities or the parental responsibilities related to giving, refusing, or withdrawing consent to medical, dental, or other health-related treatments. And the minor's child's participation in CWWA services would fall under these Section 41 responsibilities. So in this situation, in our case scenario, we have parents who are separated. Currently, they're both retaining guardianship of their child, but because of the recent court action that just gave them a joint guardianship situation. So that's what you would be looking at. And so under that scenario, each parent has the ability to register a child in a CWWA program unless there is a court order or agreement that states otherwise. And if you look at Section 40 of the Family Law Act, if you have a parent who wishes to register the child in the program, and in our case scenario, that would be the mother who's registered the child in the CWWA program. Section 40 requires that parent to consult with the other parent unless, and it's a very important unless, it would be unreasonable or inappropriate. And the Family Law Act talks about circumstances that would be unreasonable or inappropriate, and those are situations where there is a safety risk. And in this case, we have a history of violence by the father, and that would be criteria that would be considered a safety risk, and that would allow the mother to sign the child up for counseling without providing this consultation or notice to the other parent. And if that parent, the mother in this case, determines that it's in the best interest of the child to access the services, then that consultation is not a necessity. So, and we, in the Toolkit information sheet on this topic, we walk you through specific questions that you can ask the parent or the guardian when you're working with them about whether there are court orders or agreements that identify this issue, whether with respect to allocating these decisions to one guardian or to both guardians. And if you're in a situation such as I've drafted this case scenario where you do not have court orders or agreements, and if your parent that you're working with, in this situation the mother, determines it's in the best interest to provide services to the child with that one parent's consent, you are justified in doing so under the Family Law Act. What could happen in this case, and what has happened in this case, is the father has now objected to the counseling and demanded that the child no longer see the counselor. So that demand in and of itself does not have to cease the counseling. What would happen is that he would have to return to court to to get a court order, and the judge would have to make a determination as to whether the CWWA counseling is in the child's best interest. And with the broad definition of best interest in the Family Law Act, there's a very good reason for the judge saying no, CWWA counseling could go forward. I think programs get very concerned when they get these kinds of demand letters, especially ones that raise the issue of a lawsuit. And it's understandable that they're cautious in these circumstances. And so in these circumstances, it's very important that you document all the actions that you've taken, that you document the analysis that you use, and that you discuss it with your supervisors and your ED. And if there is a threat of suit, if you have a relationship with a lawyer in the community, you could just, give them a quick consult call just to make them aware of the circumstances, so that if there is some sort of court action going forward, then you at least have protected your interests and your client's interests, and you've acted in the best interest of the child. The information sheet also refers you to a August 2015 Ministry of Justice information bulletin that provides support for the toolkit. And so throughout the toolkit, we've provided links like that so that you can then look to outside resources to support you in the work that you're doing. The next issue that's raised in the case scenario, and I'll just read it to you, relates to the child. Moving on, the child, who is now 11 years old, insists that the CWWA services continue, and the child is asserting the right to have the services regardless of his parents' or her parents' position. The counselor, the CWWA counselor, is wondering if the child can receive services without a parent's consent, and is concerned about, if he proceeds that way, about record keeping and how long the child's records have to be kept by the program. So in the toolkit, we have a specific information sheet entitled Informed Consent for Minors and CWWA Counseling. And the question that we pose in the information sheet is, can a minor child receive services from a CWWA counselor without a parent's or guardian's knowledge or consent? And then we go through the analysis of that issue. So the minor child can give informed consent for CWWA services without a parent's or guardian's knowledge or consent, as in BC, the informed consent analysis considers the maturity of the child and is not based on a certain age. In this case, you've got an 11-year-old child, and I know that some CWWA programs currently consider 12 as the age that requires consent. But under these various acts that we'll go through, you'll understand that it's based on the maturity of the child, not based on a specific age, and that maturity varies from child to child. So with respect to the laws that this information sheet discuss, the statutes and the court cases, the Age of Majority Act, which you guys are probably familiar with, establishes that persons 19 and over can make decisions regarding their welfare. And then, so the group that we're talking about right now is 19 and under. There is, in the Child, Family, and Community Service Act, the CFCSA, there are provisions in there that state if a child is under 12, that the child lacks the capacity to consent. But there is a big exception in the CFCSA, which states that if the child has an appropriate developmental level and maturity level to indicate that they have the capacity to consent, that even children under the age of 12 could provide informed consent. So when you're going through this analysis as a CWWA program, what's important to consider is the type of services that you're providing. And in the toolkit and in the information sheet, we talk about the different CWWA programs that exist. There are two sort of controlling laws. So if you are in a CWWA program that falls under the healthcare provisions of the BC Infants Act, then that statute would identify the informed consent steps for minor children. And if you are not under the healthcare policy services criteria, then the CWWA services would fall under the common law practice regarding a minor's capacity to consent, and it's called the mature minor doctrine. I'll walk you through these sort of briefly, but when you get the toolkit in your hands, you can go over them more thoroughly. So under the BC Infants Act, it states there's no legal age for consent for health care. Children under 19 have the right to consent to their own health care from a health care provider if they meet the criteria. The tricky part is for you to determine whether the CWWA services you provide would fall under the health care provider definition, which is a person licensed, certified, or registered in BC to provide health care. And health care is defined under the BC Infants Act is anything done for therapeutic, preventative, palliative, diagnostic, cosmetic, or other health-related purposes and includes a course of health care. So if you look at the criteria, if you look at your professional accreditation and determine that you fall under this health care definition, then you would, and you're trying to determine whether you can work with this 11-year-old as a mature minor, then you would look to the BC Infants Act for their criteria. And the legal capacity criteria there, to be quite honest, it's similar to the legal capacity criteria under the mature minor factors. But here under the BC Infants Act, it's the provider explains the treatment to the child understands the nature and the consequences and the reasonable foreseeable benefits and risks of care. The provider has made reasonable efforts to determine the child's comprehension, and the provider has concluded that the health care is in the child's best interest. So if you explain these steps to the child and you determine that it's a voluntary and free act on behalf of the child, then you can, and you determine that he meets the criteria, then you can go ahead and treat that 11-year-old as a mature minor. And what we would encourage you to do is to document it, document the analysis, document the criteria, talk it over with your team and your supervisors, just so that you're all clear about how you're going forward. And as I stated, if your CWWA program falls under the common law analysis and doesn't fall under the BC Infants Act, you're talking about similar mature minor factors that we just went over for the BC Infants Act. So it's basically the same analysis that you're doing. And again, we would encourage you to document it, and we would encourage you to have sort of a fulsome discussion with your colleagues about it. The important part about the BC Infants Act is that there was a practice which is called a common law practice that existed before the BC Infants Act was adopted. And the law specifically states, the BC Infants Act, which was enacted in 1996, basically put in code some of these common law rules, but it also stated that it didn't displace other common law practices, meaning that if you have CWWA providers that aren't considered the licensed, certified, or registered healthcare providers, they could still proceed under sort of the old practices that had been established before the adoption of the BC Infants Act. And there's case law in court cases that supports that, and they're mentioned in the toolkit. And with respect to this analysis, in terms of the case law in British Columbia and in Canada, the Canadian courts have reviewed informed consent cases for minors, but there are no reported cases that have yet considered a mature minor's consent to or refusal regarding counseling services. The cases that have been reported are cases involving medical services. And so we can look to those cases for guidance. Every case has been addressed on an individual basis, and the courts have been flexible in their determinations in terms of determining the developmental maturity of the child, and they balance that along with the seriousness of the proposed health care treatment and the risks and the benefits to the decisions made. And those cases are discussed in the toolkit. So the only thing that you have to be cautious about with respect to this is that if you make a determination as to whether, in this case, you can go to the, sorry, we're just going to the next slide. So if you determine that you have a mature, the 11-year-old is a mature minor, and the other concern that was raised in the case scenario is what happens with these records. And so these records, if it was a mature minor child, those records would be kept separately from the mother's records, and those would be confidential in the same way that you would treat adult records, with the legal exceptions that are provided for the exemptions that you're probably very familiar with. The records would be maintained separately, and you would treat that a mature minor like any other sort of adult client. The exceptions are if the child, in terms of disclosure of the confidential records, would be if the child might cause serious physical harm to themselves or others, if the child needs protection as there is reportable abuse, or if the provider is required by court to disclose the records, or the child consents expressly to the disclosure. If by chance when you're going, let's say you were going through this analysis that we went through and you decided that the child was not a mature minor, this 11-year-old, then you would be in the situation where you'd have to go back to get parental consent to continue the CWWA counseling. But as I stated, if you had the mother agreeing to the counseling and the father objecting, you could still proceed on that basis unless there was a court order stating that you couldn't. So the other issue that the CWWA worker is concerned with is the child's records and how long would they have to be kept by the program. So in the toolkit, we have a section that specifically addresses records retention and destruction, and it talks about specifically it talks about all types of records. And as you know, records are broadly defined to include all recorded information regardless of physical format. So it includes books, documents, maps, drawings, photographs, letters, vouchers, papers, emails. And with respect to the records related to a child, and the records retention and destruction information sheet talks about it pretty thoroughly, so I'm not going to talk about it right here, but in terms of just trying to answer this question for this CWWA worker, with respect to adult client records, there are, depending upon your current grant, financial, legal, or regulatory requirements, the law, as a general rule, you have to maintain the records for a minimum of a year, and 7 years has been identified as a time frame that meets most of these requirements on a general basis with exceptions, and those exceptions are discussed in the information sheet. So adult client records should be kept for a minimum of 7 years with some exceptions, and the records of a child client should be kept 7 years after they reach the age of 19. So in this situation, when you're working with an 11-year-old, you're going to be maintaining those records for quite a period of time. So you have to think about that going forward. So the next question in the case scenario that we're going to be talking about is the mother is afraid to have CWWA services continue because of the court proceeding, and she's concerned that it may hurt her standing in court. And so she has asked for copies of her file and her child's program file to make a determination as to how she should proceed. So again, in the toolkit, we have a section that discusses records management, and it specifically, the question there is why and how should BCSTH programs keep records? And so it talks about the necessity to have records and how they should be kept, and it also has a section about program participant files and access for program participants to their file. Requests by program participants to review their files must be honored, except where precluded by law. So in this case, the mother would have has the ability to look at her file. Exceptions where it would be precluded by law may be a situation where you had a child protection matter, where she perhaps couldn't have access to some of her records, and that's complicated and requires some more analysis. But she has the ability to request to have her files and to receive copies of her file. With respect to, let's say she looks at the file and she decides that there's information in there that she doesn't agree with. The program participant can request a correction or removal of inaccurate, irrelevant, out-of-date, or incomplete information from her file. And that has to be, should be done in writing, and then you as a program have to review that request and make a determination as to whether the file should be corrected. If the program disputes the accuracy of the proposed correction, the dispute should be noted and the file would remain unchanged, but that the program participant request would stay in her file so that there would be a paper trail of the decision-making process and what her request was. The other thing to be cautious about in terms of file keeping, and this is something we addressed in the toolkit, is when you are holding on to material for safekeeping for a client, like for instance in this case, perhaps the mother gave you a copy of a journal that she was keeping, and you put it in her file. All of those items, including that journal, could potentially be discoverable under a court proceeding. So that's just something that you have to be cautious about, and we talk about that in the records management section of the toolkit and also in the subpoena section of the toolkit, which we're going to get to in a little while. So with respect to this question, so the other important part that we stress in the toolkit is to inform the program participant of all the policies through your informed consent forms, and we have sample informed consent forms, and we have case summary forms and case filing forms. So when you're closing files, you can have a way to keep track of what's been in the file, what's been removed, and why it's been removed. And just to have real clarity in your record keeping purposes helps. So this slide talks about the records retention and destruction information sheet that's in the toolkit. And again, we touched base on this because we talked about the 7-year time frame. But the important part is to really be clear about your policies and to inform the program participant of the policies. And as I stated with respect to the issue of retention and destruction, every single program has different requirements in terms of operational and administrative and funding requirements. And so all of those requirements are going to govern what you have to keep and for how long you have to keep and why you have to keep it. So there's this sort of 7-year general rule, but there are exceptions that you as a program have to wade through, and you can do it. It's just a little painstaking, and we're happy to help you get through it. And as I stated, in the records retention and destruction toolkit information sheet, there we break it down by the laws that cover the different types of organizations, and we talk about the dreaded federal and provincial laws. So we talk about BC's Personal Information Protection Act, and we talk about the Freedom of Information and Protection and Privacy Act. So we talk about PIPA and FIPA and other laws that apply, along with recommended practices as to destruction and privacy and confidentiality. So there's a lot of information in there that hopefully will be helpful for you going forward. So we talked a little bit about this. This is related to the mother asking for access to her file in terms of the information that you're able to share with her. And then the question is whether she could have access to her child's file. And it's tricky because the way I've drafted the case scenario here is the child is first starting to be seen with her consent, and then the child becomes a mature minor if we go that route under this analysis. If you make the determination that the 11-year-old is a mature minor and can stand on their own as a mature minor, then their files would be kept separate and confidential. So the child would have to allow authorization to release information to the mother as this is drafted. But again, none of these issues are easy and require a lot of analysis, and I'm happy to help you as you go forward sorting through these thorny issues. So the final question in the case scenario is the father's lawyer issues a family court subpoena for the mother's records and the child's record, and so trying to determine how to respond to that. And so in the information toolkit, we have a section entitled Responding to Subpoenas and Record Requests. And the question posed there is, how should frontline workers respond to subpoenas and requests to testify and produce records? So the important thing to remember is that it's not in the toolkit, but I'll just say, nobody likes to be subpoenaed, especially lawyers and legal advocates. So having a subpoena served on you or a record request or any kind of court proceeding is not a pleasant thing. But the bottom line is for you to know as frontline workers that you have an ability to respond in a way that is going to be protective of you and your program and your clients, and that it's a court proceeding, and that you have to sort of know how you should respond and what the steps that can be taken to protect you, but that you do have resources and the ability to respond in a way that's going to be protective. So what's important to remember as you go forward working with your client is that any information that a frontline worker is witness to, records, or collects that is kept in your files may be subpoenaed as part of a legal proceeding. Although you are considered as a third party to this legal matter, so for instance in this case, the legal parties are the mother and the father with a child. but you would be considered a third party. You can still be asked to appear as a witness or to produce records as part of the discovery process in that matter. The reason why information or records get subpoenaed is that there is a party to the legal proceeding that believes that you have material evidence that's going to help them prove their case in court. And the important thing is to know that you have an ability to file a motion with the court to set aside or cancel the subpoena or the request, and that you have a way to limit some of the disclosure of that request. So the court process varies depending upon the nature of the request and the underlying court case, whether the court case is a criminal case or a civil case. And in this case, we're talking about a family court matter, so that would be considered a civil case. So the important thing is that, to think about this is just a request for information. It is a formal request for information, but to remember that there are responses that you can use that are appropriate. So every case should be addressed on a case-by-case basis, and typically with a civil subpoena, it will be served by personal service, often by a professional process server. So if you as an individual or your program is served, the important thing is to accept service, not reveal any confidential information in response to the questions asked, and then to take that to review the paperwork carefully to make sure it's being served on the proper person, and then to advise your supervisor and or executive director of the program about the request. Your client should also be advised about the request, as your client has different legal interests than you and your program, and should probably consult with independent legal advice. She has a privacy interest in the records that may be separate from your privacy interest. So that would be an important thing to do as well. And in these circumstances, you do need to consult with a lawyer. So again, if you have an ongoing relationship with a lawyer in the community, or you have a lawyer who's willing to work with you on a volunteer or pro bono basis, they would be the folks that you would need to consult. And then they're the ones who are going to help you analyze the situation, and they're the ones who are going to consult with the other side on your behalf. What we did put in the toolkit to help folks is just a sample letter that they could send to the party who served the subpoena or records request on them, which basically indicates that they're in receipt of this request for information and that they are discussing the paperwork with our legal counsel, and that you would be in contact with them before the court date. Just to clarify that you've received it and that you're responding to it in a timely manner. With respect to what can happen in a family court or civil matter when you have a request like this and that you are going to be objecting to it, the issues that can be raised to challenge whether the evidence that you have should be disclosed or not, basically is you can argue that the evidence is not relevant and that is privileged, which means that it is protected. So the court rules that the relevant information must prove or disprove a material fact. And the judge will take that into consideration about whether this is just a fishing expedition into your file for information or whether this is really a relevant request to what's pending before the court. So the judge, in making that determination, will consider if the communication was given in confidence, in a confidential relationship, and if the confidentiality is essential to the relationship, and if that confidential relationship fosters a public good. So if these 3 items are met, which I would argue that might be what you do all day as CWWA workers, the judge must then consider whether that important privacy interest that protects the disclosure outweighs the interest in finding the truth, and I put that in quotes, and disposing of the civil case correctly or justly. And so the judge has to weigh that analysis. And what can happen is the judge can look at the records in court in camera, which means behind in the chambers in private, to make a determination as to whether these records should or should not be disclosed. And that's something that the judge does separate from having the other party see any of those records. You should be aware of the fact that BC courts have noted that documents, transition house documents that have been produced in one setting were not allowed to be produced in another civil case. So we have case law where judges have refused to disclose specifically counseling records from transition house programs on the basis that the records were not relevant to this other court matter and were privileged and did not have to be disclosed. One of the cases relates to a civil personal injury case involving an auto accident where the plaintiff had received services and counseling at a program, and the other party was trying to get access to those records, and the judge said that was too far afield, and that it was a fishing expedition, and that the privileged nature of the counseling records prevailed. And so there is some good case law out there to assist you in terms of making an argument that these records should not be disclosed. And what's important to know also, that if the judge comes back and says, okay, I'm going to allow that some of these records are disclosed in this setting, that there are also limiting conditions that you can request through your lawyer with respect to the disclosure, involving only portions of the records being released, only allowing the records to be viewed at court, allowing only a limited number of copies to be made of what's disclosed, and also having a ban on having the information disclosed any further other than within the court proceeding, and also to have identifying personal information blacked out or redacted. So there's ways to handle this so that it's not an open case, and that hopefully it's something that's manageable and not scary to address. So the other part that I just wanted to bring up before we get into the discussion section is in the toolkit we also have a section that talks about note-taking and client records, and so it's trying to give you some guidance, and this was one of the issues that was raised when we did the survey as to what should be, not only what should be in your files, but what should be in the notes. And so we tried to give you a little bit of guidance there in terms of having records that are necessary so that you can do your job, but also keeping in mind the safety of the women and children that you're working with, and that keeping that balance. Because I think you're faced daily with the need to document interactions with your clients in a clear, fact-based way, but with the understanding that anything that's recorded and collected may be subpoenaed or requested in another civil or family court case, and you want to be mindful of the woman and child safety and what notes could support that safety and also undermine that safety. So in the section, the information sheet, which is entitled Note-Taking and Client Records, we specifically say what should frontline workers document in their client record. And we go through some of the questions that you could ask yourself to sort of help with that analysis in terms of talking about the purpose of collecting and recording the information, whether the recorded information is your subjective perspective of the woman or child situation or if it's fact-based, to think about what will happen with that information once it's collected, to think about whether that information would be harmful to the woman and her children in terms of gaining access to other services or in a legal setting, and if the information could be harmful if subpoenaed and disclosed to third parties. And we also have a little section in there, just a blurb about, is it best practice to collect minimal information? And if it is, how do you do that at the same time as addressing your need to keep agency records to meet all of your obligations in terms of running your programs? So it's a information sheet that hopefully will help you in terms of coming up with a policy and a balance in terms of keeping records. And then we list, in addition to sort of providing you with that analysis, we also give you some templates, which are some sample intake forms, as I stated earlier, some sample informed consent forms, some plan of service forms, some closing report forms, some file summary forms, just sample templates that you can take back to your program that you can fiddle with to see if they help you in terms of entering the information that's necessary for the work that you're doing, for the important work that you're doing, but also to be protective of some of these other issues in terms of the safety of the folks that you're working with. Let's see. Okay, so I'm just going to overview the next steps for the toolkit, and then I think we'll go into the chat section. And as I indicated earlier, our intention is to stop the recording at that period of time so that we can have an open discussion about the questions that you've raised. And then this portion that's been recorded will be available, as I stated, on the BCSTH YouTube section for folks who weren't able to join us today. And so what will be coming your way shortly will be, as I indicated, a hard copy of the toolkit. It'll also be available to be downloaded from the BCSTH website, and the library will have copies as well. And what we're hoping to do going forward is to use the toolkit as a way to have a dialogue with you about the issues that you are faced with on a daily basis. So I'm welcoming responses by email. You can also use the CWWA listserv as a way to respond to BCSTH. I'm both on it, and Rhiannon is also on it. And then the idea would be going forward, we could have, if there was a burning issue that folks really wanted to address, we could try and have a lunchtime webinar on that one specific issue, and sort of try and use the toolkit as a training tool. And the other thing is that you, yourself, in your program, should feel free to pull out sections of this toolkit as well and have like a brown bag lunch and talk about, informed consent for mature minors, have a very exciting, robust lunch discussion about that. But really use it as it helps you in terms of going forward. The idea behind it is for it to be a useful, relevant resource for you that you can go to and get information quickly. And as I said, it links you to other information and other resources. So if you have a little bit more time and you want to delve more deeply into it, those resources are there available as links. And what we would love to hear from you is what other topics you would like to have included in the toolkit and what revisions we should do to the toolkit. specifically, I know the issue of MCFD and the statutory duty to report has come up recently on the CWWA listserv, and that was a topic that was is I know a very a lot of folks have a lot of interest in that topic. It was a little bit beyond the scope of the grant as this was originally drafted, but it doesn't mean that we can't address those issues going forward. So if we wanted to do a section on NCFD, on statutory duty to report, on other identified issues, we're happy to do that and happy to work with you to get a resource that would be useful to you. So, and this is sort of, consider us as having a big parking lot here to hold all those information and hold all those ideas and to get that information, those resources out to you in a timely manner that's useful. So I'm going to get to the next slide, which is questions and discussion. Here's my contact information here at BCSTH, so feel free to contact me by phone or by email. And now I think Rashid and I are going to attempt to open it up to questions and to a discussion. And so bear with us. We're stopping the recording, but you won't lose us. We'll still be here chatting with you.